The room had no windows. That was the first thing I noticed when they walked me in. No windows, no natural light. Just the flat white hum of fluorescent tubes overhead and the low, climate-controlled silence that federal buildings always have. That pressurized quiet that makes you feel like the walls are listening. There were 6 people on the other side of the table. 3 attorneys, 2 federal examiners from the Financial Crimes Enforcement Network, and Marcus Hale himself, partner, senior counsel, chairman of the Real Estate Investment Committee at Alderton Hale Capital Group. He was wearing the charcoal Brioni suit, the one he wore to closings, the one he put on when he wanted to remind the room that he had already won before anyone said a word. He had his hands folded on the table, and there was a smile on his face, not a full smile, more like the ghost of one, the kind that lives in the corners of a man's mouth when he believes the outcome is already decided. I sat across from him. I set my leather portfolio on the table, not a briefcase, not a banker's box, just one slim leather portfolio, the kind you'd bring to a painting. He glanced at it. The ghost smile got a little wider. He thought I had brought nothing. And to understand how that smile disappeared in under 60 seconds, how the most powerful real estate attorney in the southeastern corridor of this country sat in that room and watched his entire career evaporate in front of 3 federal examiners. We have to go back 8 months. We have to go back to the night. Marcus Hale looked me in the eye and told me I would never be anything more than a property attorney. I had been with Alderton Hale for 11 years. 11 years of 6-day weeks, of red-eye flights to closing tables in cities I barely saw outside of conference rooms, of reviewing covenant stacks at 2 in the morning, of being the person they called when a deal was bleeding out and needed someone who could read 400 pages of title abstracts in a single sitting and find the one clause that saved everything. I was not a partner. I had been told twice that I was on the partner track. The first time was after I restructured the Meridian Commons acquisition and saved the firm $3.2 million in transfer tax exposure through a tiered assignment clause that nobody else had thought to use. The second time was after I quarterbacked the Coastal Plains portfolio deal, a 9-property transaction across 3 states that closed in 31 days, a record for the firm. Both times, the partnership vote came and went. Both times I was told the timing wasn't right. Both times Marcus Hale had been on the committee that decided. I kept working. I kept delivering. I told myself that results compounded, that the work spoke, that an organization that valued excellence would eventually reward it. I was measuring the wrong currency. The night everything changed, I had been called into Marcus's corner office on the 41st floor. It was past 8. The building was mostly empty. Marcus was at his desk with a glass of scotch and a document I didn't recognize, a thick, bound document with a gold foil logo on the cover that I had never seen before. He told me to sit. He didn't look up from the document for almost a full minute, and when he finally did, he had that smile. The full version, not the ghost. The one that meant he was about to enjoy something. He told me the firm had restructured its partnership criteria. He told me the new threshold required a book of business, origination credit, not just execution credit, of no less than $4 million annually before any equity consideration would be extended. He told me this in the flat, informational tone of a man reading a weather report. Then he added the part he had been looking forward to. He said, and I want you to hear this the way I heard it, with the scotch glass in his hand, and that smile in the city laid out behind him 41 floors down, he said, you're very good at the work, but let's be honest with each other. You're a property attorney, a very capable one. But you're not a rainmaker. You're not a partner. And I think somewhere, if you're being honest with yourself, you already know that. I sat with that for a moment. I felt the specific surgical humiliation of it, not just the dismissal but the framing of it as self-knowledge, as though he was doing me a favor by articulating what I had supposedly always suspected about myself. I thanked him for his transparency. I stood up. I walked to the elevator, and in the elevator, alone, going down 41 floors, something very quiet and very cold settled into the center of my chest. Not anger. Anger burns hot and burns fast. This was something slower. This was the beginning of a project. What Marcus did not tell me that night, what I only discovered later, was that the restructured partnership criteria document he had been reading was not a firm-wide policy. It had been drafted specifically, retroactively, to apply to 2 people. Myself and a colleague named Diana Reyes, who had also been on the partner track and who had also been repeatedly deferred. The document had been created 6 days before that meeting. I know this because I still had system access to the firm's document management platform, and document metadata does not lie. Every file in that system carries a creation timestamp, a modification history, and an author attribution chain. The original author field on that partnership criteria document showed Marcus Hale's assistant's login credentials, but the revision history showed that the structural framework had been copied from a template, and the template's source path pointed to a subfolder in Marcus's personal project directory that he had apparently forgotten existed on the shared drive. It was a small oversight, a tiny digital carelessness, the kind of mistake a man makes when he believes no one is looking, when he has never once considered that the person he is dismissing might be precisely the kind of person who knows where to look. I did not do anything with this immediately. I filed it away. I kept working, and I started paying attention to a different set of things. The thing about working in real estate transactions at the level I worked at is that you see the whole machine. You see the acquisition structures, the holding entities, the escrow arrangements, the title insurance chains. You are not meant to understand everything. You are meant to understand your piece, to execute your column, to close your file and move to the next one. But I had been doing this for 11 years, and I had a habit, a professional habit, a due diligence habit, of reading entire deal structures rather than just my assigned sections. It was this habit that had saved clients millions of dollars over the years. It was also this habit that meant I had read, at various points over the past 3 years, documents that I was not strictly required to read: escrow instructions for offshore tranches, side letters referencing Zurich-domiciled holding accounts, wire confirmation sheets for transactions that closed through intermediary entities in jurisdictions I had to look up on a map the first time I saw them. None of these individually had registered as significant. In the context of a practice that routinely handled international real estate capital, offshore structures were not unusual. But I had a very good memory, and after Marcus's dismissal, I began treating those memories differently. I began connecting them. I requested a leave of absence, 4 weeks personal reasons, accrued vacation. The request was approved without comment. Marcus likely considered my exit a foregone conclusion anyway. I spent the first 3 days of that leave doing nothing. I walked. I slept. I let the compacted pressure of 11 years of 6-day weeks decompress slightly. And then, on the 4th day, I opened my laptop and began building a timeline. I want you to understand what a forensic timeline of real estate transactions actually looks like when you are building it from scratch. It is not dramatic. It is not a movie moment with string lights on a corkboard. It is spreadsheets. It is 18 browser tabs. It is public records databases and county assessor portals and SEC Edgar filings and the UCC lien registry, FinCEN beneficial ownership disclosures that became mandatory after 2021. It is cross-referencing the name of a registered agent in Delaware against of a registered agent in Nevada against a name that appears as a managing member in a Wyoming LLC filing, and realizing that all 3 names are variations of the same identity, separated by a middle initial and a suffix, the kind of small differences that are invisible to an automated matching system, but obvious to a human being who is looking for them. I had been a human being looking for things my entire career. Now I was looking for something specific. The first thread I pulled was a property acquisition that I had partially worked on 2 years earlier, a mixed-use development site in a secondary market that had been acquired by a Cayman Islands entity called Verano Holdings Limited. I had handled the U.S. title work. The acquisition price, as I recalled it, had been $47 million. When I pulled the county deed records, the recorded consideration was listed as $11 million. That is a legal mechanism. Consideration can be structured across multiple instruments, some of which don't appear in the deed, but it flagged for me. I pulled the title insurance commitment from my own archived files, the copy I had retained as part of my personal practice records, which was entirely standard and entirely within my rights to have. The commitment showed a transaction value of $47 million. The recorded deed showed 11, a $36 million gap between the insured value and the declared consideration. I noted it and kept pulling. The second thread came from a closing I had not worked on personally, but had been copied on for coordination purposes. A portfolio of 3 commercial properties that had transferred to an entity called Brennan Meridian Asset Partners, registered in the British Virgin Islands. The BVI registration was publicly searchable. Brennan Meridian had a sole director listed as a nominee service company in Roadtown. Standard. Offshore practice, nothing illegal on its face. But BVI companies have ultimate beneficial ownership declarations on file with the BVI Financial Services Commission. And since 2023, those declarations have been accessible to qualifying legal professionals with a verified purpose. I was still a licensed attorney. I still had my bar credentials. I filed the access request. It took 11 days to come back. We did. The ultimate beneficial owner of Brennan Meridian Asset Partners was listed as a trust. The trust was Swiss domiciled, and the trust's reference number matched a format I recognized. It matched the reference format of a Zurich-based fiduciary services firm called Kellner and Brandt AG, which I recognized because their reference numbers had appeared on 2 escrow instruction sheets that had crossed my desk in the past 4 years. 2 different deals, 2 different nominal counterparties, the same fiduciary reference format. Marcus Hale had signed both of those escrow instructions as supervising partner. I need to pause here and explain something about Swiss escrow records, because this is where the story becomes not just a story about one man's arrogance, but about a system that assumes its own invisibility. Switzerland's banking secrecy laws are among the strongest in the world, and for decades they functioned as a near-absolute shield for beneficial ownership information. But Switzerland joined the Common Reporting Standard, the CRS, in 2017 and signed the FATCA Intergovernmental Agreement with the United States, and those 2 instruments, working in combination, created a framework under which Swiss financial institutions are required to report account and asset information for U.S.-connected beneficial owners to the relevant tax authorities. The key phrase is U.S.-connected. If an American citizen or permanent resident is the ultimate beneficial owner of a Swiss-domiciled trust or account, that information is required to be disclosed. Require optional, not discretionary, required. And the IRS's Offshore Voluntary Disclosure Program, which had sunset in 2018, had been replaced by the streamlined filing compliance procedures. And more relevantly, by an expanded whistleblower program under IRC Section 7623 that awards between 15 and 30% of the collected proceeds to individuals who provide specific, credible, and original information about tax non-compliance involving amounts in excess of $2 million. The number I was now looking at across the properties I had identified was not in the single-digit millions. I kept building the spreadsheet. I pulled every deal I could document where Marcus had served as supervising partner and where a non-U.S. entity had appeared as the buyer of record. I cross-referenced entity registration dates against deal closing dates. I mapped the registered agent networks, the small constellation of nominee service companies that kept appearing across different jurisdictions, different deals, different nominal counterparties, but the same underlying fiduciary reference patterns. By the end of the 3rd week of my leave, I had a documented chain of 17 properties across 9 jurisdictions with a combined transaction value, the real transaction value, not the recorded consideration, that I conservatively estimated at between $240 and $280 million. Across those transactions, the gap between declared and undeclared value, the amounts that had moved through the Zurich escrow accounts and had not appeared on any U.S. tax filing I could locate, was in the range of $60 to $90 million. That is the range I brought to the tax attorney I retained on week 4. That is the number she looked at across the table from me and then looked at me and said, very quietly, that I needed to understand the magnitude of what I was about to do. I told her I understood it completely. We began preparing the submission. I want to describe what a Section 7623 whistleblower submission actually looks like because most people imagine it as a phone call or an anonymous tip, something quick and dramatic and easily dismissed. It is none of those things. A properly constructed whistleblower submission is a document package. It begins with a narrative summary, a chronological account of the information source's knowledge, stated in clear, non-speculative terms, distinguishing at every step between what the submitter directly observed, what they derived from documented sources, and what they are inferring. It is attached to an evidence appendix. My evidence appendix, when it was complete, was 412 pages. It included copies of escrow instruction sheets bearing Marcus's signature, copies of closing statements, entity registration documents from 6 jurisdictions, the BVI beneficial ownership disclosure, wire confirmation records that I had retained as part of my authorized practice file copies, a comparative analysis of declared consideration versus title insurance commitment values across the 17 identified properties, a mapping of the Zurich fiduciary reference numbers across transactions, and the Kellner and Bran AG reference format documentation, and a clean, simple summary chart, 1 page, that showed the timeline of each transaction, the nominal entity involved, the supervising partner of record, and the estimated undeclared value. We filed it with the IRS Whistleblower Office, and simultaneously, because the offshore shell company structures implicated potential Bank Secrecy Act violations with FinCEN, we filed on a Thursday. The filings were acknowledged the following Tuesday, and then I waited. The waiting is the part that doesn't appear in the story when people tell it later. People want the timeline to be clean. The filing, then the response, then the confrontation. The reality is 47 days of silence, during which I returned to work, collected my final paychecks, declined Marcus's implicit suggestion that I begin looking at lateral opportunities elsewhere, and continued showing up with the same quality of work I had always produced. Because the work was never the problem. I did not perform worse because Marcus had dismissed me. I did not perform worse because I had a federal submission pending. I performed exactly as I always had, because that is what a certain kind of person does, and because performance was now simply one of the tools in the arrangement I was constructing. During those 47 days, I also did one other thing. I consulted with an intellectual property attorney about the firm's document management system, specifically about the documents I had created during my employment, the analytical frameworks, the due diligence checklists, the deal structure templates that I had developed over 11 years, and that existed as the system under my credentials. My attorney's opinion, which she put in writing, was that certain of those materials constituted work product in which I held protectable interests, and that I should document my authorship comprehensively. I did, quietly, methodically, the way I did everything. On day 47, my tax attorney called me at 7:15 in the morning. She said 2 words before I'd finished saying hello. She said, "They moved." 3 days later, I received a call from a federal examiner at FinCEN, asking if I would be available for a voluntary interview to provide context for a pending asset review. I said yes. I asked where and when. He gave me an address, a federal building, a conference room number, and a date 8 days out. I wrote it down. I thanked him. I hung up. And then I allowed myself exactly one quiet moment of something that wasn't quite satisfaction, but lived adjacent to it, before I opened my laptop and began preparing for the meeting. The morning of the meeting, Marcus Hale arrived at the federal building at 9:45 for a 10 o'clock session. I know this because I was already in the lobby at 9:30, and I watched him come through the security screening in the Brioni suit, flanked by 2 outside defense counsel from a firm I recognized as one of the most expensive in the city. He did not see me in the lobby. I was standing near the elevators, facing away. When I turned and we made eye contact in the corridor outside the conference room, I saw something cross his face. A flicker, a rearrangement, the ghost smile appearing and then disappearing as his brain processed the geometry of the situation, tried to construct an explanation in which my presence here was coincidental, ancillary, irrelevant. His lead defense counsel leaned toward him and said something close to his ear. Marcus straightened. The ghost smile came back, partial, controlled. He nodded to me as though we were passing in the office hallway. The conference room had no windows. The fluorescent hum was the loudest thing in it. The 6 people on the other side of the table arranged themselves, 3 attorneys, 2 federal examiners, and Marcus, who sat at the center of his side with his hands folded and that smile riding the corners of his mouth. The lead examiner opened by explaining the nature of the proceeding. A voluntary information gathering session, the results of which would inform the scope of the pending asset review. She noted that a whistleblower submission had initiated the review and that the submitting party was present at the table. Marcus's lead counsel asked, calmly, who had submitted. The examiner gestured toward me. I watched Marcus's hands on the table. They were still folded, but the pressure in the fold changed. I could see it in the tendons, a tightening, a new rigidity. The ghost smile did not disappear immediately. It thinned. It went from the corners of his mouth to a single flat line. His lead counsel said something about the submission being the work of a disgruntled former employee and asked the examiners to consider the source. The lead examiner thanked him for that and said they were happy to consider the source. And the 412 pages of documentation source had provided. I opened the leather portfolio. 1 page at a time, I laid 5 documents on the table, not copies, originals. The first was the Verano Holdings title commitment, showing the $47 million insured value. The second was a wire confirmation sheet, bearing the Kellner and Brandt AG reference number, for a Zurich escrow account release dated 3 days after the Verano closing. The third was the BVI beneficial ownership disclosure showing the Swiss trust as ultimate beneficial owner of Brennan Meridian Asset Partners. The fourth was the entity cross-reference chart, clean, 1 page, 17 properties, 9 jurisdictions, the reference number pattern mapped across every transaction. The fifth was this chart, 1 page, timeline, entity, supervising partner, estimated undeclared value. Marcus's name appeared on 12 of the 17 lines. I placed it face up in front of him and did not say anything. The lead examiner picked it up and read it. She passed it to her colleague. She asked Marcus's counsel if his client wished to make a statement. His counsel said no. The lead examiner said they would be proceeding with a formal asset freeze pending the full investigation, that Alderton Hale's accounts would be subject to an administrative hold effective close of business that day, and that Marcus specifically would need to surrender his passport before leaving the building. I want to tell you what happened to Marcus's face, because this is the part of the story that people always ask about. They want to know if he cried, if he raged, if he made a scene. He didn't. Marcus Hale was too controlled for any of that. What happened was more precise than any of those things. The ghost smile disappeared. Not gradually, it simply stopped, and what replaced it was a blankness, a sudden absolute flatness, like watching a screen go dark. He was looking at the summary chart. He was looking at his name in 12 rows, and in that blankness, I could see the specific moment when a man who had built his entire identity on the certainty that he was untouchable first encountered the texture of the alternative. His lead counsel was speaking, something about reserves of judgment and procedural protections. But Marcus wasn't hearing it. He was still looking at the chart, and then he looked up. He looked directly at me, not at the examiners, not at his attorneys, at me. And I held his gaze the way you hold something heavy, steadily, without expression, with both hands, because I am a property attorney, a very capable one, and I had just executed the most complex, the most precise, and the most consequential closing of my career. The asset freeze held. The investigation ran 14 months. At the conclusion of those 14 months, Marcus Hale and two other named partners at Alderton Hale entered into a consent order with Vincent's and a parallel civil settlement with the IRS. No criminal charges were filed. This was a financial and administrative resolution, not a criminal prosecution, and I want to be clear about that because it matters. The legal system resolved this the way the legal system resolves most things at this level, with money, with consent, with the quiet, permanent dismantling of a structure that had been built on the assumption that small, careful men in big, careful suits would never be audited by someone who understood the architecture of what they had built. The total amount in the settlement was not made public. The consent order was, Alderton Hale Capital Group was required to implement a comprehensive compliance overhaul under third-party monitoring. Marcus Hale's equity interest in the firm was divested as a condition of the settlement. He remained a licensed attorney, technically, though I understand his practice has been substantially reduced. The Whistleblower Award, my award, the 15 to 30% of collected proceeds, was confirmed by the IRS Whistleblower Office 13 months after the original submission. I am not going to tell you the number. What will tell you is that it exceeded by a meaningful margin what 11 years of partnership track compensation at Alderton Hale would have been worth. I retained a portion. I used the remainder as seed capital for a boutique real estate advisory practice. Just myself, 2 colleagues I trust, that focuses on compliance-forward transaction structuring. We are very selective about clients. We are very thorough in our due diligence. And when people ask how we approach our work, I tell them the same thing every time. We read the whole document, not just our section, the whole thing. Because every document tells a story, and the story is always in the part that someone decided you didn't need to see. There is one more thing I want to say, and it is the thing that matters most. If you are someone who is sitting, where I was, sitting 8 months, before that conference room, overlooked, dismissed, told with a smile that you know your place and your place is not here. The thing is this, Marcus Hale did not lose because he was arrogant. Arrogance is common. He did not lose because he was corrupt. Corruption is, unfortunately, also common. He lost because he made a category error. He looked at me and he saw a function, a very capable property attorney, a useful piece of infrastructure, a resource to be allocated, and when no longer useful in its current form, to be decommissioned. He did not see a person with 11 years of institutional knowledge, a meticulous memory, access to every document management system the firm operated, and the specific professional expertise to understand exactly what those documents meant. He did not see someone who, when dismissed, would not rage or plead or go quietly, but would sit down at a laptop and begin building a spreadsheet. That is the most expensive thing Marcus Hale ever got wrong. Not the offshore structures, not the Zurich escrow accounts, not the shell company networks. The most expensive thing was looking at me and deciding I wasn't worth seeing clearly, because the audit was always coming. He just didn't know he was the one who would be audited, and the person who filed it had been